Unconnected.
What is this thing? Got it.
This is in the matter of the people of the state of Michigan versus Colleen Marie Barrage, file number 2024-21790FH. Mr. Dagger Margosian, this is the date and time. This is in the matter of the wait, I'm mute my computer. They changed it. I'm sorry. We got new computers. I'm trying to figure it all out. This is the date and time set for arraignment in this matter. I have Michael Dagger Margosian appearing on behalf of Ms. Barrage. I think you're the only prosecutor I have. Yep, so, all right, I'm sorry. And I have Phoebe McClure appearing on behalf of the people. Mr. Dagger Margosian, do you waive the reading of the felony information?
I do, Your Honor.
All right, and how would you like to proceed today?
Your Honor, we have reached a resolution in this matter. Ms. Barrage will be pleading guilty to meth use under 771.1, and in exchange, the information will be dismissed. It should also be noted that Ms. Barrage is already participating in recovery court, and I think she's doing well. So that, you know, that I think that's part of the reason why that was offered. Lastly, I'll just indicate that this was a fairly older case, and that's probably another reason why that was offered. So we will be entering a plea at this time. So
you said meth, but would it be a use of cocaine? Because the felony information is for cocaine.
I'm sorry, and I misspoke. It would be cocaine. Thank you.
Right, so to be an added count to use of cocaine, and then count one as well as the third offense notice would be dismissed. Is that correct?
Correct.
And that's a 93 day or 1 day or 1 year?
1 year.
1 year. Okay. And then is it 7411?
No, it would be 771.1, the delayed sentence.
Okay. Okay. So we need to talk about using these because we don't have staffing to do a lot of these because it just kind of creates an added burden, but we need to at some point sit down and talk about all these. And I think they're good. I don't oppose them, but all right. So that would be a delayed. And so I would set sentencing out 11 months to see how she does, correct?
Correct.
Yes. Yeah.
You sure?
Well, yes, this is Miss Wagner's case, so I'm just looking through the notes. That's all. But yes, that makes
okay. All right. So,
okay. I'm here, Judge. A question.
Okay.
Sorry.
Oh, I'm sorry. There you are. So Miss Adams, I'm looking for a sentencing date in 8, 9, 10, 11, March of next year. No, February of next year, I think.
Let's go with February 21st.
Okay. All right. Okay, so Miss Barrage, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, so Miss Barrage, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to an added count 2 use of cocaine, which is a misdemeanor and carries a maximum penalty of up to 1 year in jail? Do you understand that?
Yes.
Is it your intention to plead guilty to that?
Yes.
Now you understand that the sentencing agreement would be that it would be a delayed sentence. So if you successfully completed your term of probation in that 11 months, the case would then be dismissed. Is that correct, Ms. Wagner?
Yes, that's correct.
All right. And you understand that, Ms. Barrage?
Yes.
Are you satisfied with Mr. Dagger Margosian as your attorney and the advice that he has given you?
Yes.
Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Dagger Margosian?
Correct, Your Honor.
And Ms. Wagner?
Yes, Judge.
And Ms. Barrage, is that correct as far as you're aware?
Yes.
Okay. Now, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and to have witnesses against you appear at your trial and ask those witnesses questions. You have the right to have the court order any witnesses you might have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes.
All right. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you understand that?
Yes.
Ms. Barrage, do you have any questions about the rights that I've given to you?
No.
Okay, so how do you plead to the charge that on or about November 11 of 2022 in the city of Adrian in the county of Lenawee that you did commit the offense listed under the added count 2 use of cocaine? Guilty or not guilty?
Guilty.
Okay, has anyone made any threats or promises to you to induce you to plead guilty to this charge? I missed your response. I'm sorry. Other than
I
the
said no.
plea agreement, you said no?
Yeah.
Okay. Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes.
Has your attorney promised you any particular sentence or estimated what your sentence will be other than what was placed on the record? We missed your response. I'm sorry.
No.
Okay, there's kind of like a delay. I apologize. Is
Oh,
it your
okay.
own choice? It's okay. Is it your own choice to plead guilty?
Yes.
Okay, so Ms. Barrage, back on November 11th of 2022, were you in the city of Adrian in the county of Lenawee?
Yes.
And did you have cocaine in your possession that you used?
Yes.
And you had no legal right to possess that cocaine, is that correct?
No.
And you knew it was cocaine when you used it?
Yes.
Okay. You satisfied, Ms. McClure? Or I'm sorry, you satisfied, Ms. Wagner?
Yes, Judge, thank you.
All right. Has the court complied with MCR 6.302 B, C, and D? Mr. Dagger-Margosian
Yes, Your Honor, thank you.
and Ms. Wagner?
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights, and she does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defendant, the defense attorney, or anyone acting in the interest of either of them. I am going to take this plea under advisement under 771. I'm going to refer this matter to the district court probation department for pre-sentence investigation. And we are setting sentencing for, find my sheet. We said February 21st at 8:15 in the morning. Ms. Barrage, do you want to appear in person or via Zoom?
Zoom.
All right. And if you decide you want to come in person, you can always do that too. Okay.
Okay.
All right. So Ms. Barrage, you are currently at Hope House. Is that where you, no, you're just zooming from Beth or Patsy's office, right?
Yes.
Okay, so next Thursday, you're gonna have to go down to district court probation and check in. And you'll meet with a Mike McCarron and he'll do a pre-sentence report. And like I said, sentencing's not until next year,
So-
but
I have drug court that day, so just go afterwards?
so,
Okay.
or come before if you can, early at 8 is fine. But you need to stop in, they'll do a pre-sentence report, be truthful with them about your background, the events that occurred. They'll put that report together. And we'll provide it to Mr. Degemargosian. If you violate your terms of your other probation or anything, understand we may move the sentencing up, okay?
Okay,
The other thing I'm gonna order for your bond conditions is that you, your bond conditions would simply be that you abide by all terms of the recovery court and your circuit court probation, all right?
okay,
All right, and then we'll see you back on, well, I'll see you Thursday, but we'll see you back for sentencing on February 21, all right?
okay. Thank you.
Anything else, Mr. Degemargosian?
No, Your Honor, thank you.
All right, thank you, Ms. Baird. See you Thursday or next
Yep.
Thursday or whatever day it is. Thanks. All right, so I have a gentleman on a Samsung wearing a blue hoodie. What's your name?
Marquise Washington,
And who's your attorney?
Michael Dagger Mangolian.
All right, so I got him right here, so let me find you. And anybody in here have Michael Degemargosian?
I have Mr. Washington.
Okay, I was talking to them.
Oh, I'm sorry.
It's okay. I mean, I don't think you're gonna get in trouble in the near future, need to hire them, but I was talking to them. All right, let me grab your file. This is in the matter of the people of the state of Michigan versus Markeith Isaiah Washington. We have two files, 24-21741FH and 24-21742FH. I have Michael Degemargosian appearing on behalf of Mr. Washington, and I have Phoebe McClure appearing on behalf of the people. Mr. Degemargosian, this is date and time set for a pretrial. How would you like to proceed?
Your Honor, we've reached a resolution with the people on these two matters, 741 and 742. Mr. Washington will be pleading to one count of uttering and
Can you
publishing.
give me the count number?
I'm sorry, let me, on 741, it will be count 2, uttering and publishing. And additional, he will be pleading guilty to one count of R&O on 742. That would be count 2. And the remaining,
Yeah. So, Mr. Degemargosian, on file number 21741, Ms. Fade caught uttering and publishing as count 1,
let me bring that information up.
and then larceny in the building is count 2.
Yeah, it would be the uttering and publishing. So if that's count 1, that's count 1.
Sorry about that.
No, that's okay. I just was looking off a different sheet.
Okay, and let me. The other file.
And then, yeah, on 742, it would be count 2, R&O.
All right, so is that a correct recitation of the plea?
Yes.
Mr. Clerk?
Your Honor, I'm sorry. I should add that there's a suspended sentence of 6 months jail on both of the cases.
That is accurate.
As
Is
well,
that a cap?
as well as an agreement to pay the restitution back.
Do we know what restitution is, or is that gonna be determined still?
I was just gonna look that up. It seemed like we. had that.
And while she's looking that up, Mr. Degemargosian, all other charges, as well as the habitual offender fourth offense notice would be dismissed at the time of sentencing, correct?
Correct.
All right, so I'm gonna let you look that up while I swear him.
Yes.
Okay, so Mr. Washington, you want to raise your right hand?
Yes,
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
yes, I do.
So, Mr. Washington, you have heard the statement of your attorney and the prosecuting attorney is it your intention on file number 24-21741FH to plead guilty to count 2, uttering and publishing, which carries a maximum penalty of up to 14 years in prison? You can put your hand down. I'm sorry. And carries a maximum penalty of up to 14 years in prison. And then on file number 24-21742 to plead guilty to count 2, resisting and obstructing a police officer, which carries a maximum penalty of up to 2 years in prison, but with a Killebrew agreement that the sentence would be 6 months suspended. And as long as you comply with probation and don't violate, you would serve no jail time. So is it your intention to plead guilty to those counts?
Yes, Your Honor.
All right. So, Mr. Washington, are you satisfied with Mr. Dagger Margosian as your attorney and the advice that he's given you?
Yes, Your Honor.
Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Dagger Margosian, other than the suspended 6 months?
Correct, Your Honor.
Is that correct, Ms. McClure?
That's correct.
All right. So is that correct as far as you're aware, Mr. Washington?
Yes, Your Honor.
Okay. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be present until, or presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Sir, do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, Your Honor.
So, sir, get your files. On file number 24-21741FH, how do you wish to plead to the charge that on or about January 4 of 2024 in Lenawee County, is it Adrian? I just have county. I'm thinking it's Adrian, the pallet place.
Yes, that'd be the city of Adrian.
All right, and the city, when you, okay, can we amend that? In the
Okay.
city of Adrian in the county of Lenawee, that you did commit the offense of uttering and publishing, guilty or not guilty?
Guilty.
Okay, and on file number 24-21742FH, how do you plead to the charge that on or about January 13th of 2024 in the city of Adrian in the county of Lenawee, that you did commit the offense of police officer assaulting, resisting, and obstructing, guilty or not guilty?
Guilty.
All right, has anyone made any threats or promises to you to induce you to plead guilty to these charges?
No, Your Honor.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during the hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Dagger Margosian
No, Your Honor.
and Ms. McClure?
No, Your Honor.
Has your attorney promised you any particular sentence or estimate what your sentence will be in terms of length of probation, fines and costs?
No, Your Honor.
Right. Is it your own choice to plead guilty?
Yes, Your Honor.
All right, so let's start on file number 24-21741FH. So, Mr. Washington, on January 4 of 2024, were you in the city of Adrian in the county of Lenawee?
Yes, Your Honor.
All right, and did you have in your possession some checks that didn't belong to you?
Yes, Your Honor.
Okay, and did you write a check on Old National Bank in the amount of, looks like $1,000?
Yes, Your Honor.
All right, did you have permission to use those checks?
No, Your Honor.
So did you write out the check or did somebody else?
Somebody else.
Okay, but you knew that they had altered the check and then you went to the bank to cash it?
Yes, Your Honor.
All right. And when you did that, the intention was to defraud the company of the amount that you were cashing the check for. Is that correct?
Yes, Your Honor.
And the amount was,
I said $1,000.
okay, then yes, people are satisfied.
All right, let's move on to file number 24-21742FH. Mr. Washington, on January 13th of 2024, were you in the city of Adrian in the county of Lenawee?
Yes, Your Honor.
Now, at that time, did you come in contact with an Adrian Police Department officer?
Yes, Your Honor.
Was she in a full uniform so that you knew by looking at her she was an Adrian police officer?
Yes, Your Honor.
Okay, and at some point, did she try to take you into custody? She
I
tried to
got
arrest you?
I got taken to custody, Your Honor, when they found me.
Okay. So when they took you into custody, Mr. Degemer goes in, you've read the police report, but at some point, did you like try to walk away? Did you pull your hands away from handcuffs? Did you not obey a direct order from her?
No, I went to handcuffed right away. I just ran away from the house when I seen it was the police.
Okay, so the police came there and you saw them. Did they try to stop you?
They called for my name and I kept going until they found me, and then I turned around and got handcuffed.
Okay, Mr. Degemer goes in. Anything else to add to that?
Mr. Washington, you knew that these individuals were law enforcement officers and they were giving you a legal command to stop and you didn't stop immediately?
Yes, that's correct.
Satisfied.
Satisfied, Judge.
All right, so with both of the files, has the court complied with the MCR 6.302 B, C, and D? Mr. Degemer goes in.
Yes, Your Honor.
Ms. McClure?
It has.
All right, I accept all the pleas. They've been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights and he does have competent counsel. Other than the agreement to a deferred 6 month, this court has made no agreement regarding the possibility of a plea or possible sentence with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. So Ms. McClure, the restitution is $1,000.
It is, but I think there was a bank fee and that's what I was trying to look for, but my computer's not letting me.
And it's usually pretty de minimis.
Yeah.
All right, so Mr. Degemer goes in, restitution that will be ordered will be around $1,000. And I think bank fees are like $30 or whatever it might be. Is that acceptable, Mr. Degemer goes in?
I don't have an objection to that, Your Honor.
Okay,
And Judge, it is joint and several with the co-defendant Curtis Bradley, who has already pled. So if he's paid anything, that would minimize what Mr. Washington has to pay.
so,
And I think probation would have record of that.
so Mr. Washington, understand there was a co-defendant. If the
Yes.
co-defendant has paid restitution in full, you won't end up paying anything. If they haven't paid it, then you might get stuck paying it in full, but you know, you're both responsible for the full amount and for half. So it kind of goes both ways, all right?
Yes, Your Honor.
Okay, so Mr. Washington, I am going to set sentencing in this matter for May 30th at 8:15 in the morning. Are you available that day, Mr. Degemer goes in?
Yes, Your Honor.
Now, Mr. Washington, let's see where you live. Let's see. Okay, you are here in Adrian, so perfect. So, Mr. Washington, I am going to put you in a breakout room here in a minute with Mr. Moore. He's from the Michigan Department of Corrections and the probation department. I see you have a habitual offender notice. Are you currently on probation anywhere?
No, Your Honor.
Okay, so Mr. Washington, for sentencing, you can appear in person or you can appear via Zoom. Do you want to zoom in or appear in person?
Zoom, Your Honor.
Okay. All right, so I'm gonna put you in a breakout room with Mr. Moore, and Mr. Moore is gonna get your information from you and some instructions and what you need to do. You're gonna have to fill out a packet, so you're gonna have to pick that up, and then you're gonna have to come in and meet with them and make sure you do that. And when you meet with them, be truthful about your background, the events that occurred. They'll prepare a pre-sentence report. We'll provide that to Mr. Dagger Margosian. He'll review that with you before sentencing, so make sure you reach out to him about a week before sentencing, okay?
Yes, Your Honor.
And then we will see you back on May 30th at 8:15 via Zoom, okay?
Yes, Your Honor.
All right, thank you, Mr. Washington. So hold on a minute. Mr. Moore, I'm going to put you and Mr. Washington into a breakout room. And then when you're done, Mr. Washington, you can go on your way, all right?
Yes, Your Honor.
All right, there you go. Mr. Dagger Margosian, I don't think I have you on anything else, correct?
Correct, Your Honor.
All right, so why don't you send somebody else down to me? Because they're all
I'll
down
do-
there in Judge O'Savers.
I'll do that. I'll get somebody over here, Judge. Thank you.
All right, thank you. Okay. Perfect, thank you. Mr. Leper is here. Ms. McClure.
Okay, good.
All right, no, it's not connected. So I know you have Rhonda Underwood. Is anybody else a defendant? Have a case today? No? You guys students? No? So, in the matter of the people of the state of Michigan versus Elena Chapman, file number 24-21793 FH, arraignment was waived. In the matter of the people of the state of Michigan versus Michelle Harding, two files, 24-21779 FH and 24-21780 FH, arraignment was waived in those files as well. In the matter of the people of the state of Michigan versus Casey Michael McKenzie, file number 2024-21789 FH, arraignment was waived. And in the matter of the people of the state of Michigan versus Nathaniel Eugene Ross Jr., file number 24-21794 FH, arraignment was waived. Mr. Bernstein. So I have somebody, I'm going to send you a request to unmute. It looks like you are not connected to audio maybe. All right, what is your name, ma'am?
Tora Trammell.
Okay, let me find you here. Right, and your attorney is Salvatore Malaro, so I'm going to rename you. And then when Mr. Malaro gets here, he's not here right now. He's next door in front of the other judge. When he gets here, I would just ask when you come in, you turn off your radio in the background or the TV, okay?
Okay, thank you.
Thank you. I'm gonna put you in the waiting room. I do have, are you on Bruce?
Yeah, yeah, that's one of the reasons why I came up. Is he here?
Okay, he's in Zoom.
Okay, I thought he was gonna be in person.
In the matter of the people of the state of Michigan versus Elizabeth Warner, file number 21-20607 FH. This is the date, time set for request and summons for probation violation. Is Miss Warner in the courtroom? No, she is not. Miss Warner was ordered to appear on a show cause. She's failed to do so. I'm going to issue a bench warrant for her arrest. And I'm going to set bond in the amount of 25,000 cash. All right, Mr. Bernstein. Good morning. I have your client. All right, we're back with Mr. Toms. This is in the matter of the people of the state of Michigan versus Douglas Henry Toms, file number 2023-21221 FC. Mr. Toms is represented by Sam Bernstein, and I have Feed Me McClure appearing on behalf of the people. We are here on three things today. We have defendant's motion to preclude testimony, defendant's motion to preclude evidence of other acts, and defendant's motion to preclude evidence of physical violence. I received all the motions as well as responses. So I don't need you to regurgitate everything that's in them, but Mr. Bernstein, you can address your motions, please.
Your Honor, I trust that the court has reviewed the motions, and I'm comfortable with the court making a decision without any further oral argument on my part, if that's okay with the court.
That's fine, Mr. Bernstein. Anything else?
I would concur.
All right. So in this case, the defendant is charged with 1 count of criminal sexual conduct first degree, 2 counts of criminal sexual conduct second degree, 1 count of child abuse second degree, and 1 count of indecent exposure. In this case, defendant's stepdaughter accused him of repeatedly inappropriately touching her over the course of 7 years from 2006 to 2013. These are the allegations against Mr. Toms. The first motion we have is defendant's motion to preclude testimony of Stella Shanaquet. The victim in this matter allegedly reported the abuse perpetrated by her stepfather to Stella Shanaquet. Defendant moves to preclude any statements made by the victim or to Miss Shanaquet as hearsay. The people responded that they do not intend to elicit such testimony, and Miss Shanaquet will be called to testify regarding the victim's post-assault behavior, which is permissible. Therefore, I'm going to deny the motion to preclude testimony. The proffered testimony is admissible. And there's no indication that she's going to be testifying as an expert, that the victim's behavior was or was not consistent with some type of or kind of anticipated behavior. I am denying the motion, but obviously I understand there may be some potential issues closer to trial that we'll be prepared to address at that time. The second motion is defendant's motion to preclude other acts evidence. The people filed the notice on April 1 of 24 pursuant to MCL 768.27A, indicating that they intended to introduce testimony regarding defendant performing flea checks on the victim more than 50 times. Defendant takes issue with the number of times the victim testified that she experienced this, as defendant contends that it is speculative because she does not remember the precise number of times this occurred. Defendant argues that the evidence should be excluded under MRE 403 as it is more prejudicial than probative. The people responded that this information is highly probative, and it was defense counsel who solicited the precise number of instances during preliminary examination, as victim initially testified that the flea checks occurred several times. I'm going to deny this motion as well. There's no basis to grant this. Properly noticed other acts are certainly probative, particularly given the alleged continued behavior through the time period at issue here. The number of flea checks that the victim experienced is not speculative if the victim estimates the number of weeks or months they occurred and the number of times per week or month they happen. Defense counsel can obviously question the witness about how many times she remembers and how she arrived at that total, but I'm not going to exclude this evidence under the 403 test. Defendant's motion to preclude evidence of physical violence. Defendant was charged with second-degree child abuse. The testimony at preliminary examination included that defendant pulled the victim's hair, and hit her with a broom on multiple occasions. The victim also reported to police that there was an incident wherein defendant held a machete to her throat and yelled at her to feed the cat, though that incident was not testified to at the preliminary examination. Defendant argues that the only information testified to at preliminary examination can form the basis of the charges and evidence at trial. So the evidence regarding the machete incident cannot be produced at trial. Similarly, because the district court only indicated that the ongoing sexual assaults form the basis of the child abuse bindover, testimony regarding the broom incident should be precluded. In his brief, however, defendant argues that this evidence should be precluded under 404B or 403. The people respond that there is no basis to limit testimony to evidence produced for preliminary examination where the burden of proof is so low. Moreover, the people respond that this is not character evidence analyzed under 404B. So the proper test is 403, and this is the conduct supporting the charges. So it is obviously highly probative under 403 and satisfies that test. So I will deny that motion as well. And now, do we have, let me see here. In this case, we are scheduled. Let's see here. We are set for trial on April 23rd at 9 a.m. Are the people ready to proceed?
We are, Your Honor, and we have filed the full trial packet, including jury instructions, voir dire, and a proposed verdict form, and Mr. Bernstein, I believe, has filed his proposed voir dire. The only issue with that trial date that has come up internally within our office is that you also have Jeremy Sneed, however you say that, set for trial that day, and he's an in-custody defendant. So what I was going to suggest to the court, as well as through Mr. Bernstein, is obviously we keep our trial date, but Mr. Sneed's final pretrial is this morning as well, and if something happens with that's for sure going, that we have an alternative trial date set for this one, so we know exactly when that'll be. But if we don't need that alternative trial date, then we can continue on the 20th.
So I think everyone's prepared. We don't have any out-of-town witnesses flying in. Is that correct, Mr. Bernstein?
Correct, Your Honor.
So, set for trial, and what day of the week is that?
It's next Tuesday. So essentially, I'm just asking that we get an alternative date now while we have everyone present. And then by the end of the day, we'll know what's going on with Mr. Sneed, and if he is.
It's Sneed, just like Isaac.
I'm sorry, I don't know what to say. Then if his case, after his pretrial this morning, basically we'll know by the end of the day if we need that alternative trial date or not.
Ms. Adams, this was set for 2 days. Do we have an alternative date we can give?
I can look. I will tell you that Mr. Sneed is supposedly supposed to be a plea today, so I don't know if that helps.
Yeah, let's hold off. So what I'm gonna do
I've heard
is,
that, but Mr. McCready does not think he's going to.
okay, well, we never know. And it could be by the end of the week. So what I would say is, today's Wednesday. I'm gonna be gone tomorrow. So Mr. Sneed obviously can plead up to the day of trial. I don't disallow that. So whether we get an alternate day today or we get an alternate day Friday or Monday, it's not going to be any different.
Okay.
So if we'll let you know the date. I'm not going to get a date, but if you want to give me the book for future reference. So if by Monday he hasn't pled, we'll get you that alternate date. Okay.
It was just a suggestion, but
No, I appreciate it.
Yeah.
Okay, all right, so Mr. Bernstein, you'll prepare the orders. I will follow up with you guys Friday or Monday. And if obviously Mr. Sneed pleads today, Ms. McClure will probably reach out to you, Mr. Bernstein, okay?
Okay, thank you, Your Honor. Appreciate your time.
All right, thank you all. Have a good day. Elizabeth Steele, can you start your video, please?
Can you hear me?
I can.
Hold on, I gotta figure this out. Can you see me?
I see you now. Let's see here. Is your name Elizabeth Steele?
Yeah.
And what
It
are you
used to-
here for?
It used to be Warner.
Ah, got it. Thank you.
Finally, after 8 years, I went back to my maiden name.
All right. So, Miss Warner, you were supposed to be here at 8 o'clock this morning, and I have issued a bench warrant for you. So, in the matter of the people of the state of Michigan versus Elizabeth Jean Warner, it is now 9:17. This matter was set for 8 a.m. File number 21-20607FH. Ms. Warner, we are here on a show cause for violation of probation. Let me find your file here.
I never got anything in the mail either, just so.
Well,
Like,
how'd you know to come here today?
I just happened to look online and I saw
Okay,
that I
so
had
Miss
court.
Warner, are you still on Pine Street?
Nope.
Did you change your address with the court?
I changed my address with the state of Michigan.
Well, that is not the court. So you
Okay.
can change your address everywhere in the world, but if you don't physically tell your probation officer where you moved, we have valid service because it's the last address you gave to me. So ma'am, we're here today because you have failed to report to probation since August of 2023. You have failed to pay fines and costs and restitution. So that is what we are here for today. Do you understand that?
Yes, ma'am.
Now, you do have the right to have an attorney represent you at this hearing and any subsequent hearings. If you can't afford to hire one, we will appoint you one at public expense. Do you need an attorney appointed to represent you?
Yes, ma'am.
All right, so what I'm gonna do is set this over to Friday morning in person, and then I will have an attorney here to speak with you, okay? So Friday morning at 8 o'clock in person.
Okay.
All right, so we'll see you back that day. Thank you.
Thank you.
And I'll quash the bench warrant.
All right. Thank you.
Mr. Noe.
Good morning, Your Honor. I've got Mr. Klein here in my office. Are you ready for that one?
Sure. It's the only one you have with me, right?
Okay, into my lobby. Let me get him.
While you get him, Mr. Noe, we're gonna step off the bench for just one moment. So we'll be right back, okay?
Thank you. I'm gonna log out real quick and log back in, but I'll be in the waiting room.
What's that? Do you want to? Oh, no, I'm okay. Yeah, thank you though.
Yeah, we didn't know.
Oh, that's weird. Yeah.
But we got it down. Before it was here, so. Who's his attorney?
Well, it's Rhonda, but Glacier has to meet with him apparently.
Is Jack Noyes here?
I don't know.
He texted him.
Yeah, I was just about to. Here.
86 to 80. We're just waiting for Mr. Glazier to meet with your client there.
All rise.
All right, we can be seated. All right, Mr. Klein. Mr. Noe though. Is this your case? All right, so this is in the matter of the people of the state of Michigan versus Benjamin J. Klein. File number 23-21327FH. I have Charles Noe appearing on behalf of Mr. Klein, and I have Phoebe McClure appearing on behalf of the people. So, Mr. Noe, this is the date and time for pre-trial. How do you wish to proceed today?
Your Honor, in this matter, we'd like to set this matter for a jury trial and also schedule with the court a, I find it efficient, not just in this case, but in every case, when you've got a case that's been hanging around this long, except for jury trial, to set a bench conference date as well.
All right, so in this case, Mr. Klein is charged with operating while intoxicated third offense felony, which can carry anywhere from 1 to 5 years incarceration, has a mandatory 30 days in jail with at least 48 hours to be served consecutively. Oftentimes I defer the remainder. There is a COBS agreement or a Killebrew agreement, it looks like, that if you were to plead charge, there would be agreement, there would be no Michigan Department of Corrections sentence. And okay.
That is all accurate, Judge.
I'm sorry.
That is all accurate.
Okay. And I do show a January 29 of 27. District Court, January 29 of 2007 and December 20 of 2027 prior conviction. So this is just a true third. So this is a one-day trial, I'm assuming.
Yes.
So,
Okay, just for everyone's information, if there is a conviction, he will be taken into custody that day. So. Let's see what we got. And bench I'll set a final pretrial, and then the two of you can schedule a bench conference with my staff
that's
whenever
fine.
you're ready.
I'll start an
Okay.
email chain. I'll start an email chain with your office and Miss in the prosecutor's office. I can contact Miss McClure. Miss McClure, she has my email. I have hers. We'll set that up.
So I have a one-day jury trial scheduled with a female from the Michigan Department of Corrections, Erica Miller. Is that yours?
I think it is actually.
Yeah.
I don't remember. What day?
June 26th. Mr. Noe, are you available June 26th?
Bear with me just 1 minute.
Unfortunately, I'll be right in the middle of a 3-day jury trial
Okay.
next door in Judge Olsaver that I do anticipate going.
Okay.
I'm not available.
July 2nd.
I am available then.
I also am available then.
All right, so I'm going to set this for July 2nd of 2024 at 9 a.m. I am going to set final pretrial for June 26th at 8:30 in the morning.
What was that date again, Judge?
Pretrial, June 26th. I'm going to require that.
Judge, I'm not going to be available then. I'm away with family on that day, out of the state.
June 5.
June 5, I can do them already in front of the court. I don't have a pretrial that day, anyways.
Say that again.
I'm available that day.
Okay. So June 5 of 24 at 8:30 in the morning. So I'm going to require then, because I have no availability the middle of June. So jury instructions, voir dire questions are all going to be required to be filed by May 29. And then I will set June 5 for a motion deadline. If there are any motions, because I will not be available to hear them for the next 2 weeks.
Okay.
All right. And if you need a bench conference, you can call Miss Adams anytime and she will squeeze you in. Right. I have filled out a scheduling order and I signed it. So we will get a copy of that out to both of you. Is there anything else we need to address?
No, you're
I think I'm
not.
gonna have to people.
All right, very good. Your bonds continued. Thank you, Mr. Noe.
Yeah.
Judge Eston, Mr. Lepper, I just received a message from Mr. Glazier that he's stuck on Zoom in front of Judge Olsaver, but as soon as he's available, he'll come over.
We figured it'd be all morning for that one, so, yeah, that's, thank you though. So I have a gentleman with a beard and a red shirt. What's your name, please?
John Cochran.
Who's your attorney?
I don't have one that I know of.
Okay, spell your last name for me.
Cochran.
Got it. All right. All right, this is in the matter of the people of the state of Michigan versus John Albert Cochran, file number 2021-20332FH. So Mr. Cochran, are you out or are you incarcerated somewhere?
I'm still in jail in Jackson County.
Okay, so
Okay.
you're currently in jail in Jackson County. All right. So for the record, on March 14, before that, we received a letter from Mr. Cochran asking to take care of a case that he has here, which is a bench warrant for failure to appear for a probation violation hearing on January 3rd. So let me get there. So, Mr. Cochran, a request and summons, let me double check. What's this? So let me keep going. So Mr. Cochran, we're going way back. All right, so it looks like I issued a bench warrant for you for failure to appear for a violation of probation hearing on January 3rd of 2024. Who's your PO here?
What's that? I didn't hear you.
That's me.
Who's your probation officer, Mr. Moore? Okay.
Yeah, Tom.
So so I'm scrolling back now to find, looks like you posted bond to get out of the bench warrant of jail. Hold on. This is like an old file. Keep going. It's not the bond. Okay, so it's backwards. All right, so let me get back there. So the violation of probation, there was a request and warrant for probation violation filed with the court back on August 22nd of 2023, which states that the defendant has committed the following technical probation violation that on or about August 10 of 23, John Cochran pulled away from Jackson police officer Bean during a lawful arrest that led to the officer discharging chemical agent to gain control. And then non-technical, hold on, you gotta wait. I gotta go through and read your rights. So then the allegation is you committed a non-technical violation of probation and that on or about July 27 of 23, it's alleged that you violated a personal protection order by having contact with a Kimberly Lowe. So those are the current, that's the most recent allegations, Mr. Moore, is that correct?
Correct.
Okay, so the probation violation hearing was set on January 3rd of 24, and you failed to appear for that. And then, as I said, you sent us a letter saying you wanted to take care of this. So we brought you in. You are currently on probation for carrying a concealed weapon, which means if you are attempted carrying a concealed weapon, is that right, Mr. Moore, attempted?
It is, give me 2 seconds.
I'm sorry?
I have for Jackson. Yeah, concealed weapons attempt, correct.
Okay, so the maximum penalty if you plead guilty or found guilty could be up to 2.5 years in prison. Do you understand that, Mr. Cochran?
Yeah, I guess.
Okay, so Mr. Cochran, you do have a right to have an attorney represent you at this and all subsequent hearings. Would you like an attorney appointed to represent you?
I guess I'll have to, yeah.
Okay, so, all right, so I'm gonna have to get an attorney to represent you. And because you're at the Jackson County Jail, I'm gonna do it this morning. Miss Adams, is there any way you can email Sam Milaro, Matt Murphy, Rhonda Underwood, and see if any of them are available to pop over for this quick violation of probation?
Okay, sure.
All right, so I'm gonna change your screen name real quick, and then I'm gonna get someone to talk to you in just a minute, all right?
Yep.
Are you serving a sentence right now or
Yes,
pending?
Yes, I am. I've been given a county here and I'm serving the rest of it. Should be done by the 17th of May.
Okay, that's good. All right. So give us a second. We'll get an attorney here. Going to take this to Ms. Adams. Miss Adams, can you send the paperwork to Rhonda, or did you already do that?
Yes, Judge, I sent that to her yesterday.
Did you send her the VOP and the contempt, or?
I did, yes.
Ms. Underwood, thank you so much. So we are back on the record in the matter of the people of the state of Michigan versus John Cochran. Ms. Underwood, Mr. Cochran reached out to us because he had this violation of probation and a bench warrant and a contempt of court for a violation of probation, and he wanted to take care of it. He is currently incarcerated in Jackson County. Miss Adams said she sent you the paperwork.
She did.
All right, he has asked for court-appointed counsel. So I am going to assign Miss Underwood and Mr. Cochran to a breakout room. And Mr. Moore is his probation officer, all right?
Thank you.
All right, Mr. Cochran, you're gonna see on your screen, it'll pop up, join breakout room. Just click on join. What were you gonna say, Mr. Moore?
Maybe Ms. Underwood would like to speak with me before speaking with him. I'll give her an
Great.
update.
Great.
Okay, so Miss Underwood, I'm gonna pop you in a breakout room with Mr. Moore. So Mr. Cochran, you just hang on a minute.
Reset. Or is he gonna speak to my attorney?
All right, so Mr. Moore and Miss Underwood, I'm gonna close that breakout room and I'm going to open a breakout room with Miss Underwood and Mr. Cochran. So like I said, Mr. Cochran, when you get the invitation to join, just click on join. When Miss Underwood comes back, I'll just bring you back in myself, okay?
Okay. Yes, ma'am.
There you go. All right, I'm gonna close that breakout room. Oh, it's gonna close, but it's gonna close slowly because I reset the time. All right, there we go. All right, so we are back on the record with Mr. Cochran. Miss Underwood, how do you wish to proceed?
Thank you, Your Honor. I've discussed this matter with Mr. Cochran and with Mr. Moore. Mr. Cochran will be pleading guilty to the violation this morning, Your Honor. Mr. Moore is going to recommend time served due to Mr. Cochran's current circumstances and the time he's doing. Mr. Moore is going to recommend time served and discharge from probation. And he and I are both willing to waive the probation violation report on that and have sentencing today.
Okay. So, Mr. Cochran, you want to raise your right hand for me?
Yes, ma'am.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Can you state your full name for the record?
John Albert Cochran.
Okay, very good. And Miss Miller, if you want to come up here on that bench behind here, we'll take you next, okay? So, Mr. Cochran, you've heard the statement of your attorney and Mr. Moore, their agreement, they basically struck. So is it your intention then today to plead guilty to the violation of probation?
Yes, Your Honor.
All right. So do you understand there's an agreement that your probation would be revoked and terminated? So you won't be facing any prison term or anything like that. You understand that?
Yes, Your Honor.
Are you satisfied with Miss Underwood as your attorney and the advice that she's given you?
Yes, Your Honor.
Okay. Do you understand, though, you do have a right to contest the violation of probation charge and to have a trial on it?
I'm okay with it.
Okay, I got to go through your rights with you, though. So do you understand that throughout the trial, you will be presumed innocent until your guilt is proven by a preponderance of the evidence?
Yes, Your Honor.
You have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you might have to appear at that trial. Do you understand all of that?
So, is there going to be another trial? Is that what you're saying?
So I have to go through your rights. So I have to go through, like I have a script and I have to read through it to make sure you understand that you don't have to plead, you could have a trial, and I have to go say all those things or I could get in trouble with my boss, okay?
Yes, ma'am.
All right. Okay. So you do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand that?
Yes, Your Honor.
All right. And on the other hand, you understand that you do have a right to testify if you want to testify at your trial?
Yes, Your Honor.
How do you, okay, and how do you wish to plead to the charge that you pulled away from a Jackson County police officer during a lawful arrest on or about August 10th of 23? Guilty or not guilty?
Guilty, Your Honor.
And how do you plead to the charge that you violated your probation by violating a personal protection order on or about July 27 of 23? Guilty or not guilty?
I was guilty.
Okay. Do you understand that by pleading guilty, you'll be giving up your right to a trial as I've already explained to you?
Yes, Your Honor.
Has anything been promised to you to get you to plead guilty?
No.
Has anyone threatened you in any way to get you to plead guilty?
No, Your Honor.
If I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes, ma'am.
Is it your own choice to plead guilty?
Yes, Your Honor.
All right. So, Mr. Cochran, you were placed on probation, and a term of your probation was not to commit any new crimes and also to report any police contact with the probation department. Is that correct?
Yes, Your Honor.
So on August 10th of 2023, did you come in contact with the Jackson police officer?
Yes, Your Honor. I pulled in her driveway.
And you what?
I pulled into to Miss Lowe's driveway. Yes, Your Honor.
Okay, So you violated the did you talk to Miss Lowe that day?
No, Your Honor. She didn't.
But you knew you weren't supposed to go to her house, is that correct?
Yes, Your Honor.
All right, and you pulled into her driveway?
Yes.
Okay, all right, and then, did the police, on August 10th though, and that was on July 27. So on August 10 though, did you come in contact with a Jackson County police officer?
Not that I'm aware of. I didn't pull away. What do you mean by pull
Well,
away?
no, hold on. Did you have contact with the police officer and they maced you? They pepper sprayed you or something?
That was the same day. That was the same occurrence.
Okay, so I have July 27 and August 10th, but you're saying on July 27th, the day that you pulled in to Miss Lowe's driveway, hold on, let me talk. You also had contact with the police officer.
Yes, that's the same ordeal.
Okay, and when she tried to arrest you, did you pull away from her?
I was just trying to, they threw me to the ground.
Okay, but you resisted her in some way. Did you try not to be arrested?
No, I didn't try not to be arrested. They threw me to the ground, handcuffed me, and then maced me.
Okay, so when they tried to handcuff you standing up, did you not put your hands out?
That was not an option. They yanked me out of my truck and threw me to the ground. They didn't try to stand me up and handcuff me.
Okay, what charges are you in jail on?
On the domestic violence between me and Miss Lowe.
Okay, and so, and then the police officer at some point, she pepper sprayed you or something?
Yeah, I was already handcuffed and I face down on the ground.
Okay, Mr. Moore, as to count one.
All right. Yeah, he's in, and just to clear the record, he's in jail serving a new conviction for assault to degree bodily harm, less than, and a domestic violence, but he's doing a year in jail in 93 days.
Mr. Moore, what I'm asking is count one, he says he did not resist arrest in any way.
Perhaps that clause should be stricken.
That's fine. That's fine.
So we'll strike that one and I'll accept the plea on the violation of the personal protection order. Okay, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel, Ms. Underwood and Mr. Cochran. So Mr. Cochran, your attorney has advised that you're willing to waive a delay by having a pre-sentence report and you're wishing to be sentenced today. Is that correct?
Yes, Your Honor.
All right. So Ms. Underwood, is there anything you'd like to say on behalf of Mr. Cochran?
Just briefly, Your Honor. Mr. Moore has figured up the credit in this matter. Mr. Cochran has 138 days of jail credit, Your Honor. And he's also going to be in jail for, as Mr. Moore said, at least the next year. We believe it appropriate, Your Honor, to sentence Mr. Cochran to time served and discharge in this matter, Your Honor.
All right. Can I sentence Mr. Moore to jail? You said Mr. Moore, Ms. Underwood. You said,
yeah.
You said Mr. Moore, so I was like.
I corrected myself. I thought I did.
Mr. Moore needs some quiet time. So, all right.
Thank you.
So, Mr. Cochran, is there anything you'd like to say on your own behalf?
No, Your Honor.
All right.
And the fact that while being incarcerated, went to a DBT class here in the jail, and I've almost completed the MRT program. I got one more week, and it's for DBT skills to help me make better decisions. And I've got a certificate for that already. And I've stayed in the class to continue on until I'm out of jail with Shirley Wilson from Lifeways.
Well, I'm glad to hear that, Mr. Cochran. I know the Jackson County Jail offers a lot of programming, and I'm glad you've taken advantage of it, because you have to make some changes or you're just going to stay in jail. So it is the sentence of the court that your probation will be revoked and terminated. I will give you credit for 138 days, and that's unsuccessfully revoked and terminated. Mr. Moore, is there anything else?
That said, I'll send you over a discharge, Your Honor, terminated unsuccessfully.
All right, so Mr. Cochran, we're going to send over somehow to the Jackson County Jail 4 copies of your notice of right to, 3 copies of your notice of right to appellate review. I need you to initial and date 1 copy. They'll send that back to me just to acknowledge you received the paperwork. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days, all right?
I'm kind of confused about it. It's just discharging me off probation. What does that mean? I mean, am I
It means
done?
you're not on probation with me anymore, or Mr. Moore.
Okay, so I'm done with this.
Unless you want to be,
No,
No?
I was feeling like there was going to be another case against me or something. I just didn't
No.
understand.
No, I gave you credit for time served, discharge your
All right.
probation, all right?
Thank you very much, Your Honor.
All right, thank you, have a good day.
You too.
Underwood, I have. Okay. Well, you're Haley Seaver. Are you done down in Judge Olsaver's, Miss Underwood?
I'm sorry?
Are you done in Judge Olsaver's
No,
court?
not yet.
All right, well, I have, all of you guys went to Judge Olsaver's and I had nobody. So I've been sitting here all morning without a PD, but I do
Your Honor,
have.
I believe.
Hold on. I have Mackenzie Miller. She's been here since 8 o'clock this morning. Can I take care of her?
Yes.
Is it? Do you use one on the sheet? It don't matter. Doesn't matter. Okay. All right. So this is in the matter. Why don't you stand up at that podium for me? All right. This is in the matter of the people of the state of Michigan versus Mackenzie Nicole Miller. I have Rhonda Underwood appearing on behalf of Mackenzie Miller, and I have just you. I have Phoebe McClure appearing on behalf of the people. This is a date and time set for pretrial. Mackenzie is here in person. Miss Underwood, this is the first pretrial. Miss Adams, I don't see a notice. Well, oh, never mind, it was backwards. So how do you want to proceed today on behalf of Mackenzie Miller?
Your Honor, Ms. Miller and I are still looking at this. I would ask for a pretrial, maybe the end of May, Your Honor, if that would be agreeable.
That's fine. So Miss Adams, I'm going to set this out to May 29 at 8:30. Can I get a notice for her, please? All right, pretrial conference, May 29 at 8:30. So you won't need to do a notice on that one. And Miss Underwood, if there's any resolution, obviously you can get her in on a day other than a Wednesday. Is there a plea offer on this file?
This time, Judge, the plea offer would be as charged, and we would work on getting rid of some of her other cases, and then also would be in agreement with some sort of sentence agreement.
How old
But it
are you?
is as charged on count 1.
You're 24. Okay, is she eligible or any?
I don't believe she's eligible for HIDA.
I'm already on HIDA.
Okay.
Okay, so, and so Miss Underwood, it's as charged, and Miss McClure is open to any kind of sentencing discussion. So if you ever want to set a bench conference with me, that is fine.
She has a couple other open cases that, again, would be willing to negotiate with this one.
Are they upstairs or downstairs?
Downstairs.
All right.
Thank
So
you,
it's
Your
for
Honor.
similar or same conduct.
Need to think about what we're doing. Yeah. All right, have a seat right behind you and we will get you a notice of hearing, okay? Those chairs don't work. They came at the courthouse. I always feel bad for people trying to sit on them. Okay, so Miss Underwood, anybody else in here of Rhonda Underwood? No, I have no one else. So unless you want me to issue bench warrants on DeAndre, no. Morris, okay, hold on. So is DeAndre Morris brought here today? From MDOC?
No.
All right, so Miss Underwood, in the matter of the people of the state of Michigan versus DeAndre Marquis Morris, file number 23-21553 FH. Mr. Morris is not here today from MDOC via Zoom or in person. I do want you to know that I did receive a report on competency back on January 31 of 2024. I still don't have fingerprints, which I can't figure out why I can't get fingerprints on people who are incarcerated. And I do not have a notice for today either. So, so I don't have a notice for today's hearing, and I'm gonna guess then I don't have a writ from the prosecutors for today, since there's no notice in the file, but I can set it for another day and require Mr. Morris to be brought in person so we can fingerprint him.
Okay, I do see a note in here that a writ was done, but maybe it wasn't followed up on.
Okay, so I'm gonna set Mr. Morris over to.
And we have an order for fingerprints.
Yeah, I know, I signed him, but. So let's set him over to May 15 in person. At 8:30 in the morning. I'm gonna make it in person, and we need to make sure that gets to MDOC. So Ms. Adams, is it easier for you to do it, or you want Ms. Underwood to do a stipend order?
I think the prosecutor's office just does a writ, Judge.
Okay, so Ms. Underwood, you can do the stipend order to adjourn to May 15 at 8:30 in the morning, and the prosecutor will make a note to make sure the writ is done. And he is incarcerated in Macomb, so he's not that far away. And all right, so that takes care of that one. Rhonda, hold on, because if I have any bench warrants, I want to issue them before I lose you. You waived arraignment on that one. Do you want to do Ms. Sebring now?
Your Honor, Ms. Sebring has a case in district court that we're just gonna ask to adjourn these. I talked to Haley yesterday and she's aware.
Okay, so let's take those then and do the adjournment. So, in the matter of people of the state of Michigan versus Haley Gracelyn Jeanette Sebring. Take a deep breath. File number 21-20520 FH, 21-20521 FH, 21-20522 FH, 22-21037 FC, 22-21038 FH, 24-21746 FH, 24-21747 FH, and 21-20382 FH. I have Rhonda Underwood appearing on behalf of Ms. Sebring and Mr. Bayonetto. Are you on behalf of the people?
Yes, Your Honor.
This is the date and time set for a pretrial on all of those. Where would you like me to adjourn these to, Ms. Underwood?
Well, I would say 3 weeks out, maybe.
So I go 3 weeks. That takes us to about May 22nd.
Thank you, Your Honor.
All right, so we'll set a pretrial for May 22nd. The record should reflect Ms. Underwood did state that she spoke to Ms. Sebring yesterday and advised her she would be doing this. So we'll see you back on that day. Hold on, Ms. Underwood. That one, this one, this one, this one, this one, this one, this one.
That was Raglis and Cordova, Your Honor.
All right, and Mr. Cordova and Mr. Raglis. So Mr. Cordova is not in jail. So Mr. Cordova here? No,
Your Honor. Maybe not. Hang on.
Yeah, he is. Okay, let me call the jail.
Well, Your Honor, can I go back over? Because
everybody's over there.
Oh, they may have an MDOC that was misbehaving that.
Okay, all right, fine.
I will just go check, Your Honor. Thank you.
Okay, bye. Miss Adams, my email is not set up on this computer yet. Can you email like Sam, Matt, and see if any of them can back down?
Yes.
Because I do have Mr. Malaro, one of his clients.
Judge, earlier you listed the arraignments who had waived. Were there any updates from what was on the docket printed yesterday?
Harding waived.
Harding, okay.
So I had Chapman waived, Barrage waived. Oh, but you were here for Barrage.
Yeah.
She pled. Harding waived, McKenzie, Ross.
So we still have Gant and
I have Gant and I have Rogers. So, yeah, but the retained attorney isn't here.
I know, that's why I was wondering, usually they're,
There is a no, oh,
I told them that there was a waiver process because he's from out of town and not super familiar. So I'm wondering if.
Jen, do you need your client brought down?
Yeah, you might as well.
Okay.
He said he.
Miss Adams, are you able to see if somebody scanned in a waiver on Rogers?
Rogers, let me check.
And I'm looking for a phone number for the attorney.
Do
Do you have an attorney for that, or phone number for that attorney?
Phone number, I found the phone number, Judge.
Okay.
248-635-2540. And I do not see a waiver.
Hi, this is Judge Anna Marie Anselmo, and I'm calling from the Lenawee County Circuit Court. So I have a file on Mr. Michael Darnell Rogers.
Yeah.
And attorney Jeffrey Perlman is on the file, and the prosecutor mentioned that she had spoke to the attorney about the waiver process for waiving circuit court arraignment, and I don't have a waiver form.
Okay, yeah, we would like to do that. So how do I get that waiver form?
Well, so today's arraignment, we're in court. Is your client in custody?
No.
Do you think that you guys could zoom in real quick and we could do the waiver on the record?
Yeah.
Because you would need his signature to do the waiver of arraignment.
Okay, I'm so sorry.
No, it's fine, it's fine.
Okay, fine. What is the Zoom ID?
Okay, so hold on one second. So my Zoom ID is 993-558-321. And there's no rush. I'm doing my normal docket. Oh, you're welcome. Bye. Okay. So, hi. All right, so this is. We get. He's zooming in right now.
Yeah, I just texted him your Zoom number.
I already did that. I gave it to him.
Okay, could he waive his client's appearance?
I don't think he can. That's why you have to do the form. I mean, unless he can get me a waiver form sometime today, that would be fine. But
well, I'm not gonna worry about it. He asked that I just said, just log into Zoom.
I don't think you can, John. I don't think you can. I think you have to have your client present for the arraignment.
I think so too.
So. A felony arraignment today for arraignment, you have to have your client present, right? That's what I always. Right. We can't waive the presence of it. Okay, so. Did you get fingerprinted today?
No.
Okay, so I'm gonna need him fingerprinted today before you take him back. Okay, and Miss Adams, is he gonna be able to go to the jail to get that done?
If there's an order in the file, I can send it over to the jail right now.
Well, I'm sure there is. Let me see.
I believe you signed an order last time.
We usually do it right after arraignment, so. I'm sure there is. If there isn't, Miss Adams, I will sign another one.
And I am so sorry, who is it for, Judge?
Stephen Joseph Lepper. I guess I hadn't called the name, so you wouldn't know that, but this is in the matter of the people of the state of Michigan versus Stephen Joseph Lepper. file number 2023-21466FH. I have John Glazier appearing on behalf of Mr. Lepper, who's present in the courtroom. And I have Phoebe McClure. Yep, Phoebe McClure appearing on behalf of the people. This is the date and time set for a pretrial conference in this matter. So, Mr. Glazier, how would you like to proceed today?
Mr. Lepper wants to set this matter for trial.
Okay, so because he's in custody and because he needs to be here in person, I am going to set a firm trial date for him, because right now it's not a firm date. Okay, so.
And Judge, would you just go over the plea agreement and your comps? Thank you.
All right, so I have, the plea offer previously was that the defendant is charged with prisoner possessing contraband, which is a 5-year felony. He has 1, 2, 3, 4, 5, at least 5 prior felonies, which means if he was convicted at trial, this would become a life offense. Do you understand that, Mr. Lepper? Okay, the plea offer is to plead to an attempted, which carries a maximum penalty of up to 2.5 years in prison, with a Cobb's agreement that, he probably needs to be at the podium, but it's okay. The Cobb's agreement is that his sentence would be 5 to 30 months. So the minimum sentence would be 5 months. So if he were to plead to the attempted, I would sentence him to 5 months. And then unfortunately, he's incarcerated right now with MDOC. So there would be no credit for time served. So his sentence would be 5 months to 2.5 years. Do you understand that, Mr. Lepper?
Yeah. Could we talk back to chambers? I just thought of something.
Okay, yeah, I don't have any PDs other than you, so that's fine. So Mr. Lepper, you're gonna stay where you are. And then I'm gonna go back in the jury room with Mr. Glazier and Ms. McClure.
Yeah.
You can come back there.
I can or can't?
You can.
Okay.
Yeah.
Mr. Malaro, I'm trying to bring in Mr. Trammell. He's stuck in, oh. Oh, Mr. Perlman and Mr. Rogers. Good, thank you.
Hello, thank
Okay.
you. Good morning.
Good morning. So this is in the matter of the people of the state of Michigan versus Michael Darnell Rogers, file number 24-21795FH. I have attorney Jeff Perlman. What's your P number, Mr. Perlman?
Yes, good morning. Jeff Perlman, P80517.
All right, good morning. On behalf of Michael Darnell Rogers, who has appeared via Zoom, this is a date and time set for arraignment. Mr. Perlman, do you waive the reading of the felony information?
Yes, Your Honor.
Have you received a copy of the prosecutor's request for discovery and witness list?
Yes.
All right, so Mr. Perlman, how do you wish to proceed today? Do you wish to stand mute and have the court enter a plea of not guilty? Or does your
Yes,
client wish to avail himself of a plea bargain?
I would, well, we had discussed the plea bargain. I would just ask for another pretrial date, and as to the arraignment, my client would enter not guilty, duly stand mute and waive formal reading.
All right, so I will enter a plea of not guilty on behalf of Mr. Rogers, and I will set another pretrial. I can do June 5 or July 3rd. Which would you prefer, Mr. Perlman?
Okay, let me check. June 5 looks good.
All right, so I will set this for a pretrial on June 5 at 8:30 in the morning. You have the Zoom number, so you can both Zoom in for that hearing. And Mr. Rogers, your bond conditions are continued. And thank you, Mr. Perlman.
Thank you. Have a great day.
You as well. Thank you.
Bye.
You're all set, Mr. Rogers. All right, so are you ready?
We're ready.
All right, so this is in the matter of the people of the state of Michigan versus Stephen Joseph Lepper, file number 23-21466FH. I have John Glazier appearing on behalf of Mr. Lepper, and I have Phoebe McClure appearing on behalf of the people. We did have an opportunity to have a sidebar and have a discussion regarding this matter. Mr. Glazier, how do you want to proceed today?
Your Honor, my client's going to enter a plea of guilty to attempted possession of contraband by a prison, and I'd like to place some things on the record if I could.
Okay, could you both stand at the podium just so we get better audio for recording purposes?
I can.
And Ms. McClure, you'll be amending the information to add a count 2 attempted prisoner possessing contraband?
Yes, I'm working on that currently.
Thank you so much. All right, so Mr. Glazier, you may proceed.
Yeah, Your Honor, I've advised my client that we had a discussion back in chambers that it would be a Cobb's, or I guess it'd be a Cobb's, that if he pled to that, he would get fines and costs that are, what were they,
$130 and $68.
Okay, so it's
$198.
just like I said, right? I told the only consequence would be obviously that he'd have another felony on his record. He has a number on there already. He's aware of that. And, you know, they might take that money out of your account at some point as the fines and costs. And he's willing to do that. And Your Honor, for a factual basis, if you just want to use the transcript that found it, that's fine too.
So a no contest?
No, you want to be guilty or no? Yeah, no contest, but yeah.
Ms. McClure, is that all right?
Yeah, I have no objection. What would the basis be?
Lack of memory or civil liability?
Lack of memory, or yeah, that's fine.
Okay, okay. All right, so Mr. Lepper, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, Mr. Glazier, can you kind of put the mic between the two of you? So, all right, can you state your full name for the record?
Stephen Joseph. Well,
all right, so Mr. Lepper, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention today to plead to an added count 2, attempted prisoner possessing contraband? No, I'm sorry, to plead no contest to that count with the understanding that your sentence would be $130 of court costs and or $130 crime victim rights fee and $68 in state costs.
yes, ma'am.
Okay, are you satisfied with Mr. Glazier as your attorney and the advice that he's given you?
Yes, ma'am.
So we've discussed the possible sentence in the court, and you fully understand what your sentence will be? You're gonna find some costs?
Yeah.
Okay, okay. There won't be incarceration, there won't be, okay. And if a guilty plea is accepted, there will be no trial. If a no contest plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have a right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, You may be giving up the right to appeal issues that would be otherwise appealable if you were convicted at trial. Do you understand that?
Yes, ma'am.
Do you understand that any appeal from this conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. So do you have any questions about the rights that I've given to you?
No, ma'am.
How do you want to, remember your answer will be no contest or not guilty, okay? One of those two. So how do you wish to plead to the charge that on or about May 24 of 2022 in Madison Township in the county of Lenawee that you did commit the offense of attempted prisoner possessing contraband?
No contest.
Okay. Has anyone made any threats? Well, yeah, there's been promises made to you and you already know what your plea is. So you're taking the plea based on the fact that this offer has been made to you, correct?
Yes, ma'am.
No one's forced you or promised you anything other than that?
No, ma'am.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead no contest? Mr. Glazier?
Oh, yeah.
Ms. McClure?
None, Your Honor.
Has, we already talked to which senses, and it's your own choice to plead no contest?
Yes, ma'am.
All right, so Ms. McClure, would you like to place factual basis on the record?
Yes, Judge, in this case, on August 4th, 2023, there was a preliminary exam in the district court wherein the people showed, at least by probable cause, that this defendant did possess, while being a prisoner at Gus Harrison in Madison Township, that he did possess marijuana wax, THC. It was a controlled substance, and that was found in a book in an area where this prisoner was located. And see, as that was testified to at the preliminary exam, the people had asked that that be sufficient for the factual basis here at the no contest plea.
So the book was in his possession, in his area, within his possession, in his room?
I don't remember the exact room that they said, but I thought it was his cell.
Okay. Would you agree with that, Mr.?
We agree that that's
Glazier?
a sufficient factual basis, sure.
So based on the facts placed on the record and from the information contained in the transcript from the preliminary exam, as well as the police report, the court finds beyond a reasonable doubt that on or about May 24 of 2022 in Madison Township in the county of Lenawee at the Gus Harrison facility, that the defendant was lawfully incarcerated and a prisoner at that time and did have in his possession THC wax, which is a controlled substance and not allowed to be possessed. Therefore, he did commit the offense of attempted prisoner possessing contraband. And the court will accept the no contest plea. Has the court complied with MCR 6.302 B, C, and D? Mr. Glazier?
Yes, Your Honor. I think I didn't put it on there, but the supplemental is
dismissed as well. Okay. Ms. McClure?
It has.
Right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. There is a full sentencing agreement that was placed on the record in this file, and the court will, of course, follow that. I have to set it for sentencing, so we're going to set a sentencing date. Because it's a felony, I have to, through MDOC, do a PSI. Is that correct, Mr. Moore?
We can waive the PSI.
Mr. Moore, can they waive the PSI on this? I don't know that we can.
In this situation, I don't see why not, but
Okay. So, Mr. Lepper, we can do a pre-sentence report. You know what those are, right?
Yes.
And then I would set sentencing for mid-May, and then you could appear in person or via Zoom. There is no victim, so we don't have that issue to address. So do you want to waive your right to a pre-sentence report?
Yes.
And do you want to be sentenced today?
Yes.
Okay. And do you need to talk to your attorney about that? Or
No, we're
Okay.
set, Judge.
Just, we need to make sure he does get fingerprinted today, though.
yeah, but you understand you can't leave. Okay. So we've already sent an order for fingerprints to the jail. What door would they go in at the jail, you think?
We know.
You know where to go? Okay. So, all right, so, before the court passes sentence, Ms. McClure, anything to say on behalf of the people?
Nothing on behalf of the people.
Mr. Glazer, anything on behalf of your client?
No, you're.
Mr. Lepper, anything on your own behalf?
No, ma'am.
All right, well, it is the sentence of the court. Well, in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offenses, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and protection of society. Miss Adams, are you working on appellate rights?
Sure am, Judge.
Okay, thank you. So it's a sentence of the court that you will pay $68 in state costs and $130 crime victim rights fee. And you do have the right to appeal this sentence. So in just a second, my assistant's going to bring in your notice of right to appellate review. There's going to be 3 copies. The top copy you need to initial and date. That's just to acknowledge you received the paperwork. That'll go on my file. The other 2 copies are for you. If you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right?
Yes.
When are you eligible for parole?
I want to say March 30th of 23rd.
Okay, so just a second and Miss Adams will be in with that. Miss Underwood, I have Mr. Malaro.
Just had to see you got it.
I had seen.
Yes, Judge, I'm here.
Where are you? Oh, the golf
I'm right here.
course. Okay. All right. So hold on a second. I got Rhonda Underwood. So I'm gonna call the jail real quick. So, hi, this is Judge Anslon. I have jail Zoom 1, jail Zoom 2, jail Zoom 6 open. But I am ready for Jeremy Sneed, Haley Sebring. I'm ready to start with them. Yes. Oh, actually, you know what? I misspoke. I do not need, you're all set. I do not need Haley Sebring today because we already took care of court. So I can do Jeremy Sneed, Xavier Williams, and who is, let's see. I'll take those 2 first, and then you can just put the rest of them in.
Okay.
All right, thank you so much. Bye-bye. The record should reflect, I've received back the signed copy of the notice of right to appellate review on behalf of Mr. Lepper. Thank you, Ms. McClure. So, Ms. Trammell, this is in the matter of the people of the state of Michigan versus Tora Nicole Trammell, file number 23-21467FH. I have Salvatore Malaro appearing on behalf of Ms. Trammell. Mr. Malaro is the golf course because they won't give him a camera for his computer. So, and I have Amanda Wagner appearing on behalf of the people. So, Mr. Malaro, how would you like to proceed on behalf of Tora Trammell?
Your Honor, I've been in contact with Miss Wagner on Miss Trammell, and I think we could get this matter resolved if we could schedule this for a bench conference like next week. So that would be my request, Judge.
Okay, I don't have a lot going on. You want to do it now?
We can.
All right, so what I'm gonna do is I'm gonna put the courtroom, you're not gonna hear me. I'm gonna put the courtroom in the waiting room. Could I ask that you leave the courtroom for 1 minute? And then when I'm done, we'll have someone bring you back in, all right? So I am going to open up a breakout room. No, actually, I'm gonna put the courtroom in the waiting room.